Hi everybody, I'm Sheikha Barania, a solicitor of England and Wales, and I work in a large national law firm, but I'm based in the city of London. Now, this year we've seen COVID-19, we've had ultimate lockdowns and so forth in the UK. What it is undoubtedly a lot of new businesses and new ideas will come out of this storm. If your company has multiple shareholders, and by multiple I mean two or more, it is advisable to have a shareholders agreement drawn up by a qualified solicitor in the jurisdiction that governs your company. In layman's terms, it is a contractual agreement between the shareholders of a company and entrenches how a company should be run. A shareholders agreement can regulate how changes in the company in the future will be dealt with, including how decisions will be made, what would happen if a shareholder wanted to leave or became ill, and most importantly, what would happen if the shareholders had a disagreement. Lawyers are able to draft and insert provisions into a shareholders agreement which deal with any disputes between the shareholders if a dispute was to arise. So if there is a dispute, a shareholders agreement contains a clause which stipulates a formal procedure to deal with that dispute. Now, those of you businessmen and women who've experienced a commercial dispute will know it's no walk in the park resolving such a dispute. It is costly, it's time consuming, and it is very, very stressful. So to mitigate those factors, a clear ADR clause, which is an alternative dispute resolution clause, should be included in your shareholders agreement. Now, this allows the shareholders to agree on a method of dispute resolution in the event a dispute arises. So by including an ADR clause, the shareholders agree that they will use an alternative form of dispute resolution as a step prior to, or at least alongside, court action. So as well as saving your client valuable time and costs, you're potentially preserving a valuable commercial relationship between your client and the other shareholders. It's not uncommon that clients have multiple ventures with the same group of shareholders in different companies. Now, going into an adverse litigation is going to affect his long-term future relationships with those shareholders. Moving on to anti-dilution clauses. So your lawyer may advise you to include an anti-dilution provision in the shareholders agreement. Dilution of a shareholder's equity happens when the company issues more equity shares, where the subscription price paid by the new investor is lower than that paid by the original investor. The value of the original investor's stake in this case will fall, as well as the percentage shareholding. So an anti-dilution provision protects the shareholder class that has the benefit of it, which is normally the original shareholder, also known as the protected investor. So the inclusion of a anti-dilution clause, while it protects and enhances the economic position of the protected investor, it can discourage new investors from investing in said company. A very common but interesting provision which protects the rights of both majorities and minority shareholders are the drag and tag rights. So a drag along clause has the effect that if the majority shareholder in a company is selling his shares, the minority shareholders are dragged along and must sell their shares on the same terms and conditions agreed by the majority shareholder. This is useful for purchasers who want to buy 100% of a company. Tag-along provisions allow the minority shareholders to join the majority shareholders' deal if the majority is decided to sell. This protects the minority shareholders, so they do not have to be left behind once the majority stake has been acquired and is now owned by a new entity or individual. In United Kingdom company law, the Companies Act, for example, assumes that the shareholders and directors of a company are different people. A shareholders agreement can provide the shareholders with veto rights on reserved matters. Reserved matters are those decisions the shareholders believe should not be left to the discretion of the directors, although the directors are responsible for the day-to-day management of the company's affairs. Therefore, the shareholders agreement needs to provide for those reserved matters where shareholders' consent is required in order for that decision to be taken on behalf of the company, as well as an Articles of Association drafted bespokely for your company. One means of protecting everyone's interest is a watertight shareholders agreement. A shareholders agreement provides a legal framework which secures stability, consistency, and the future success of your company. Have a Merry Christmas and a Happy New Year, and my contact details are below if you need any legal advice or services.